Let's move to this now. Coalition talks are still underway in hung councils around the country, but if you voted for a party and are unhappy with the ultimate coalition partner, what happens? Do you actually have any legal recourse? Let's unpack this with constitutional law expert Pierre. Pierre, thanks for your time. Appreciate it. Sorry for keeping you holding due to the breaking news. Let's start with the answer to that question, right? Does the citizen have any legal recourse if the party they voted for is now going into a coalition with another party which they did not want to be in power?
Well, the recourse they have is at the next election, they're not going to vote for that party. The voting is a political act. It's not a legal act. And yes, if you are a member of a political party, you have a right for that political party to act in terms of its constitution. If it doesn't, you can go to court and have that decision declared invalid. But if the party doesn't have in its constitution commitments that it will not make arrangements with specific other parties in coalitions, you have no recourse to the courts. You can go to the courts, but you will lose. Your recourse is political, it's not legal.
Yeah, makes sense. So is there a timeline then for coalitions and councils to actually be formed? Because Salga was saying that they have 14 days. Is that the case, though?
Yes, in terms of the legislation, there has to be the first meeting of the council where the speaker must be elected and where the mayor must be elected. It must happen within 14 days after the election was called. So the day that the IEC formalized the election results. At that meeting, there must be a vote for the speaker and the mayor. Of course, if there's no coalition, then it's just a free-for-all, and the election is what it is. We don't know what the outcome might be. So there's obviously pressure on people to have some kind of agreement before that election would happen.
Yeah, I guess that's the question, right? Because we've seen in Nelson Mandela Bay, when there were fights between the DA and UDM, etc., the council would basically not be able to do its work because they could never reach a quorum. And then it was delayed and delayed and delayed, and we're left without a mayor. What happens now if a coalition agreement can't be reached by parties?
Yes, so what happened in these cases, there's been a case in Tshwane where for 2 or 3 months a new mayor couldn't be elected. There is a provision in the constitution that allows the provincial government to intervene and to suspend the council and to have and propose an administrator, and within 90 days, under very strict conditions, to then have another election. But the Constitutional Court has just confirmed the decision that that intervention by the province into Tshwane was unconstitutional and unlawful, because you cannot just do it because your own party and other parties who don't agree with the results of a mayoral election or what they think the results will be, for collapsing the councils and refusing for the council to proceed. So it's very complicated. That is an option, but that option is legally constrained. The other option is that 2/3 of the members of the council could vote to dissolve the council, and then there must be a new election, but then you need 2/3 of the members of council to support it.
Yeah, it's very tricky. And obviously when it comes to another election, still overseen by the IEC to ensure independence.
Yes, so there will have to be then another election in those cases, and it will be on exactly the same way. We happen to have elections for every city council in South Africa on the same day, but there's nothing in the law that requires this. So you can have elections staggered because the council was dissolved either by the province, the MEC, or by the council itself in the way that I described.
Lastly, Pierre, of course, we've seen some South Africans, in particular in eThekwini, who were complaining about the fact that they registered to vote, but their names weren't on the voters' roll, and they believe that's why there's no outright majority for the ANC in eThekwini. The IEC said that because these are local government elections, that they could declare, and then at a later stage, if they're taken to court, that they could amend and allow for a re-voting. Was that the correct approach from the IEC? Is that correct?
I'm not so familiar with the specific facts of this case. We do know that if in a specific municipality there is not a free and fair election, the court can in that case declare it invalid. What the IEC, I don't really know what the IEC is saying here.
Yeah.
I haven't read about that, so I really don't understand the question.
All right, that's fine. The IEC just said that, they were going to declare the election, even if there were objections, because they could have revoting in a municipality if they were forced to by the electoral court. So that was the question. But thank you so much for your insight. Appreciate it. Constitutional law expert Pierre de Vos.